والملائكة ولكن البر من آمن بالله واليوم الآخر والملائكة والنبيين وآتى المال على حبه ذوي القربى واليتامى والمساكين وابن السبيل والسائلين وفي الرقاب وأقام الصلاة وآتى الزكاة والموفون بعهدهم إذا عاهدوا والصابرين في البأساء والضراء وحين البأس أولئك الذين صدقوا وأولئك هم المتقون. يا أيها الذين آمنوا كتب عليكم القصاص في القتلى الحر بالحر والعبد بالعبد والأنثى بالأنثى فمن عفي له من أخيه شيء فاتباع بالمعروف وأداء إليه بإحسان ذلك تخفيف من ربكم ورحمة فمن اعتدى بعد ذلك فله عذاب أليم. ولكم في القصاص حياة يا أولي الألباب لعلكم تتقون. كتب عليكم إذا حضر أحدكم الموت إن ترك خيرا الوصية للوالدين والأقربين بالمعروف حقا على المتقين. فمن بدله بعدما سمعه فإنما إثمه على الذين يبدلونه إن الله سميع عليم. فمن خاف من موص جنفا أو إثما فأصلح بينهم فلا إثم عليه إن الله غفور رحيم. صدق الله العلي العظيم. صلوا على محمد وآل محمد.
Assalamu alaikum, everyone. Thank you for coming tonight for this very important topic, writing an Islamic will. A topic that I personally have a lot of questions about, a topic that we don't often think about, even though it's very important. Because there's a stigma around this topic that if you think of the will and writing will, that means client is to establish the frameworks and the processes to protect their interests and legacy, both during their life and after they pass away. In addition to his planning practice, Muhammad has experience advising clients on immigration, nonprofit, and corporate matters. He has served in various capacities with several nonprofit organizations for 15 plus years, where he has been using his legal and analytical skills to advance his community. We are honored to have you with us today, Brother Muhammad, and Now, without further ado, I would like to welcome Samah Sayyid Saleh first to, as I said, discuss the Islamic aspect of writing well. After Salat ala Muhammad wa ali Muhammad.
والسلام على أشرف الأنبياء والمرسلين حبيب إله العالمين أبي القاسم المصطفى محمد وعلى أهل بيته الطيبين الطاهرين اللهم صل على محمد وآل قال الله تعالى في كتابه الكريم بسم الله الرحمن الرحيم كتب عليكم إذا حضر أحدكم الموت إن ترك خيرا الوصية للوالدين والأقربين بالمعروف حقا على المتقين. My dear brothers and sisters, one of the realities that is often ignored and people try to not think about as much as the reality of death. This is a reality that will happen to every single one of us. And as believers, as mu'mineen, of course, we believe that death is not the end. We transition from one life to another life, from one realm to another realm. Death is a bridge that we cross. And everyone crosses this bridge with their deeds, with their a'mal. وَكُلَّ إِنسَانٍ أَلْزَمْنَاهُ طَائِرَهُ فِي عُنُقِهِ وَنُخْرِجُ لَهُ يَوْمَ الْقِيَامَةِ كِتَابًا يَلْقَاهُ مَنْشُورًا اقرأ كتابك كفى بنفسك اليوم عليك حسيبا. Everyone goes with their own book of deeds. فأما من أوتي كتابه بيمينه فسوف يحاسب حسابا يسيرا وينقلب إلى أهله مسرورا. If your book is given in your right hand, then you will be happy. وأما من أوتي كتابه بشماله. Allah subhanahu wa ta'ala then gives us the example of what the sadness and the frustration that will happen to those who fail the test with Allah subhanahu wa ta'ala. So in our life, we have to make sure that we pass that test. And in passing that test, we have to fulfill our duties and our obligations in this life. And before we leave, we all have an opportunity to amend, to fix, to mend some of the struggles that we had, some of the challenges that we had in this life. And one of the ways to fix things once we leave, for our children, for the inheritors, for people that stay behind, is to leave behind a will. Leaving behind a will, there's a lot in the will. A lot of people think, for example, will is only about money. No, will is much greater than that. Will is about your beliefs. The will is about your prayers and your fasting and your hajj and your khums and your obligations towards God, towards people, towards the community. And writing a will is something that is extremely, extremely important. From an Islamic perspective, it's important. And from a legal perspective, we will find out how important it is, because you live in a country that they'll come and they'll take half of your wealth, or I don't know how much, but if you don't have a trust, if you don't have a will, you haven't appointed and designated how you want your money and your assets to be spent, the government will take a big portion of it. There's ways to protect yourself. I'm not going to talk about that. We'll leave that to the lawyer. But I will talk about the importance of writing a will. Writing a will. And what do we write in the will? What should we cover when we are writing a will? So Allah subhanahu wa ta'ala says in the Quran, كُتِبَ عَلَيْكُمْ إِذَا حَضَرَ أَحَدُكُمُ الْمَوْتِ إِن تَرَكَ خَيْرًا الْوَصِيَّةُ لِلْوَالِدَيْنِ وَالْأَقْرَبِينَ بِالْمَعْرُوفِ حَقًّا عَلَى الْمُتَّقِينَ. كُتِبَ عَلَيْكُمْ. Whenever you see كُتِبَ عَلَيْكُمْ, what does that signify? Obligation. كُتِبَ عَلَيْكُمْ الْقَصَاص. كُتِبَ عَلَيْكُمُ الصِّيَامِ. However, here, scholars, they say it's not wajib to write a will. Why? Because at the end it says حَقًّا عَلَى الْمُتَّقِينَ. This is for the muttaqeen. If you're a pious person, you will write a will. And not only a pious person, someone who's smart, someone who thinks ahead, someone who's futuristic, they're going to write and plan ahead for what's going to happen. At the end of the day, we come in this life, we live, we eat, we sleep, we buy, we drink, we have businesses, we do everything. When you leave, at least leave some document to say, this person, I want this to happen with my wealth. I have this shortcoming. I need to do this. I need to do that. Leave some type of document so that when you leave. Now, كتب عليكم إذا حضر أحدكم الموت إن ترك خيرا. If you leave any khair, what does khair mean? If you leave any assets, any wealth, إن ترك خيرا الوصية, you put a wasiyah للوالدين. So Allah subhanahu wa ta'ala says, not only in your life you take care of your parents. If your parents, and what does this mean? This means that some people, we leave this life and our parents are alive. So does it mean that only when I'm in a senior citizen and I'm so old, that's when I write a will? No, write a will anytime. إن ترك خيرا للوالدين والأقربين حقا على بالمعروف حقا على المتقين. Think of the walidain, think of your parents, and think of the aqrabin, think of your family, think of your relatives, right? Give them something. This is what the religion of Islam is telling us. Leave something behind for your relatives. And this is something very important. There was a man during the life of the Prophet. He died, and then the Prophet, he came and he heard that this man, his children are begging in the street. So Rasulullah sallallahu alayhi wa he said, what happened with their father? Their father had money. What happened with it? They tell him, Ya Rasulullah, he gave all of his money away. Rasulullah sallallahu alayhi wa he became angry. And he said, if I had known earlier, I would not have allowed him to be buried in a Muslim cemetery. Meaning that you can't make your children and your family become beggars because you want to do sadaqah. No, there's a portion for everything. Give your family, but also give the poor. Do good deeds, but there is a share for everyone to go around. So now, this is the wasiyah, writing a wasiyah. How can a wasiyah be? A wasiyah could be an oral dictation. For example, there are witnesses, and you say, this is my wasiyah, I want such and such to happen. This is a perfectly valid from an Islamic perspective. Does this apply right now? No, because we live in a government where they want to see legal documents, and this is why, and say, this is what he told me. So you need to have a document. Now, scholars say it is highly recommended, but then we have many narrations from Rasulullah, from the Ahl Bayt, that talk about the importance. Rasulullah, he says, Al-wasiyah haqqun ala kulli Muslim. Every Muslim should write a wasiyah. And it doesn't matter how old you are. You're young or you're old, have some document. And we will explain what you need to write in it. Someone might say, I don't even have money. Should I even write wasiyah? Yes. Everyone should write a wasiyah because there's a lot of things that could go in a wasiyah. In another hadith it says, Al-mahroom man hurim al-wasiyah. The one who is mahroom, meaning the one who is basically taken away from him, the one who does not have a wasiyah, or the one that has not been given an opportunity to write a wasiyah, to have a will. Now, what should a person put in a wasiyah? There are 4 or 5 things, 4 points that four things that should go in a person's wasiyah from an Islamic perspective. The first is your wasiyah is your opportunity to declare your faith. How beautiful is it that a person leaves this life, but there's a document that says this person lived as a Muslim, and this person bears witness that there's no God other than Allah, and that Rasulullah is a prophet, and that the first Imam is Ali ibn Abi Talib, and the second Imam is Imam al-Hasan, and Imam al-Hussein, and Imam Zayn al-Abidin, pointing out all your Imams, pointing out your belief. This is a testament of faith. You have that opportunity to write it down. Someone says, why? Because you want your children. This is a legacy you're leaving behind. Let your children see this, that our father, our mother, they testified. This is what they left this dunya. After living for a long life, this is what they believed in. And this was a testament of their faith. And Allah subhanahu wa ta'ala describes in the Prophet how prophets of Allah, وَوَصَّى بِهَا إِبْرَاهِيمُ بَنِيهِ وَيَعْقُوبُ. Ibrahim and Yaqub on their deathbed, what do they say? يا بني إن الله اصطفى لكم الدين فلا تموتن إلا وأنتم مسلمون. They gather their children and their family and they tell them, this is the most important thing. More important than money, more important than wealth, more important than the assets. I'm leaving behind this legacy of faith. I'm leaving behind this legacy of iman. أم كنتم شهداء إذ حضر يعقوب الموت إذ قال لبنيه ما تعبدون. Yaqub, he was dying, he gathered his children and he tells them, who do you worship? ما تعبدون من بعدي قالوا نعبد إلهك وإله آبائك إبراهيم وإسماعيل وإسحاق إلها واحدا ونحن له مسلمون. So this is the greatest legacy. If you were able to come in this life and live and leave behind the legacy of faithful children, leave behind a legacy where you have placed an imprint of iman on your family and your children, and you leave, then you will be in a good place. This is more important than leaving behind the millions. This is more important than leaving behind the assets. This is the most important thing, leaving behind a good legacy of mu'mineen. Why? Because if you're raising your children to be mu'mineen, then you're going to have someone who prays for you. You're going to have someone who recites Fatiha over your grave. You're going to have someone who recites Quran for you. So this is one thing that goes in a wasiyah, a declaration of faith. A declaration of faith. And this is the last thing a person will hear before they shut down the grave. There is talqeen. It's done when a person is dying. They come, they tell him, قول, say, أشهد أن لا إله إلا الله, أشهد أن محمد رسول الله. This is one time. Another time is right before they close the grave. It's mustahab for a family or a person to come and they say even hold the person. Hold the person from their shoulders and shake him. Ya fulan, ibn fulan, when the angel of death comes to you, when the angels from Allah, munkar wa nakir, or for the mu'mineen, mubashir wa bashir, they come to you and they ask you about your Lord, about your qibla, about your prophet, about your imams. فَلَا تَخَفْ وَلَا تَحْزَنْ. And tell them, be very clear, Allah Jalla Jalaluhu Rabbi, wal-Qur'anu kitabi, wa Muhammadun Nabi, wa Aliyun Imami, wal Hasan Imami. This is the last thing that a person hears. And they say that the soul hears. So write this down. This is one. Second, you write down in your will anything that you owe to anyone. I borrowed $1 from someone, I have to write that down. Because I can't afford standing in front of Allah subhanahu wa ta'ala and I have stolen $1. I have taken one, whatever it is, taking something that is the haqq of someone else, taking it wrongfully, I need to write it down. Some of us sometimes, maybe I'm borrowing something and then I die. You never know. Maybe I borrowed something very small, very insignificant, but I died. This is why we should always write it down. Always write it down, and a will could always be updated. So you write down, and this is why when the wasiyah, when the inheritance is divided, before it gets divided according to the laws of Islam, according to the laws of the Quran, Allah says, "Min ba'di wasiyatin yusi biha aw dayn," meaning you have to come and take all of the dayn out, all of the inheritance, and anything this person borrowed from another person, or any specific wasiyah, and then they come and they divide it according to the laws of the Quran. And sometimes dayn is financial and sometimes it's not. Sometimes I've hurt people with my tongue, with other things. So maybe it's very important to go and apologize or to write down any haqq that I have towards another person. So this is the second. So first you write down your faith, the testament of faith. Write that down. Even if you don't have any money, let your wasiyah just have that. I bear witness that there is no God other than Allah and Prophet Muhammad and the Imams of the Ahlul. This is sufficient. Second, you write down if you've borrowed anything from anyone, you've taken anything from anyone, even $1, you don't want to stand in front of Allah on the Day of Judgment. Third, anything you owe to Allah. We're always worried about what we owe other people, but what about haqqullah? God has a haqq upon us. What are some things that I owe to Allah? Salah. A lot of people, they have salah, they have not prayed. Write that down. And write it down during your life. Maybe I'm starting to make it up. Write it down. Now someone might say, this person, they didn't pray their whole life. What's the significance of writing it down? How is that going to be? We don't know. Maybe Allah subhanahu wa ta'ala will be merciful with a person. It's wajib upon you to write it down, and it's wajib upon the eldest son to make it up, and the family, they could make it up later. This will be something that will alleviate and remove the pain and the suffering. You don't know. Allah is very merciful. And maybe someone at one point in their life, they weren't praying, they were fasting, but now they decide on changing. But once they decided on changing, they did tawbah, then the angel of death came and visited them. So Allah knows what's in the hearts. The important thing is you write it down. You're not playing a game with God that someone says, I'm not going to pray and I'm just going to write it down. No, it's not like that. It's for someone who is sincerely planning on changing their life. So write down your salah. Of course, there are certain things, obligations that cannot be made up while a person is alive. The only thing that someone could make on your behalf while you're alive is Hajj. Hajj, you could give niyaba if you're unable to go. If you're unable to go, you have an excuse, you could pay someone, send someone to go and perform the Hajj. However, salah, zakat, khums, fasting, while you're living, you can't have someone make it up, but you write it down. So write down if you have not gone to Hajj, and Hajj became wajib upon you. When does Hajj become wajib upon you? When you're financially, when you're physically capable, when you have no legal issue blocking you, then Hajj becomes wajib on you. Now it becomes wajib, and the moment it became wajib, it's wajib every year. So you write that down, and this is something that is very important. And the fourth point, and the last that we write in the will, is the distribution of wealth. We come in this life empty-handed, and when we leave, how do we leave? Also empty-handed. Whatever I had in this dunya, this was just something that we were just borrowing, we were holding. وَتَرَكْتُمْ وَلَقَدْ جِئْتُمُونَا فُرَادًا. Allah says in the Quran, you come to us, وَلَقَدْ جِئْتُمُونَا فُرَادًا كَمَا خَلَقْنَاكُمْ أَوَّلَ مَرَّةٍ وَتَرَكْتُمْ مَا خَوَّلْنَاكُمْ وَرَاءَ ظُهُورِكُمْ. You left behind what we gave you we gave you a brief time to use this. This house you're living in, this was just temporarily yours. You were just borrowing it. This car, you were just holding it on for a short while. This land, you were just temporarily holding it. Then someone else will hold it, and someone else will come and hold it, and someone else. So these things that we collect during this life, we should write it down. Now, how is the inheritance distributed when a person, how is our wealth distributed? You come and you take all of the wealth. How much is all of the wealth? This wealth is divided into three. Two-thirds of it, they say the moment a person becomes sick, a moment becomes ill in their illness that they're going to die. Even before their death, they come and they tell this person, Yallah, no more using your money. This money you don't have the right to use this money anymore. If someone is in their illness that they're dying in, so that way someone can't come and, oh, I'm dying, I have 5 days left to live, I'm going to come and give all my money to, for example, one person. No. At that time, two-thirds of your wealth, you can't do anything with it anymore. And once a person dies, two-thirds of their money, that is right away, it's taken and is divided to the inheritors based on the laws of the Quran. This is not a Sunni thing. This is not a Shi'i thing. These are the laws of inheritance in the Quran. You could find them in Surah An-Nisa. لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ. A wife, she inherits 1/4. If she has children, she inherits 1/8. And there are certain laws that are mentioned in the Quran that are very clear. It's not disputed. 1/3 of your wealth, you could do whatever you want with it. You want to give it to a charity. You want to give it to one of your favorite children. You want to give it to your neighbor. You want to give it to your friend. You want to give it to any person. That 1/3, you could do whatever you want with it. 2/3, the children, they have fun with it. They do whatever they want. They go buy Lamborghinis and fast cars. And 1/3 of it, you could do something good with. So this is something I want to benefit from it. And then 2/3, let the inheritors do whatever they want with. So these are the 4 things that need to be pointed out in a will, in an Islamic will. One is your beliefs. The second, if you owe anything to anyone else. The third is if you owe anything to God. And the fourth is how you want your money to be distributed. Yes, brother. No, I didn't say that. No, no, no. When I the not the medical, I didn't say medical. Yes, when a person dies, 2/3 of their money is divided amongst the inheritors. But if a person, they say that this doesn't have to be that when a person dies. This is when a person is in their terminal illness. They're going to die, they come and they tell him, that's it. You have no right to use 2/3 of your money. So the 1/3, you do whatever you want with it. The 1/3, you could give it to one person, one daughter, one son. Sometimes, in Islam, لِلذَّكَرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ, the boys, they get double the girl. So some fathers, some mothers, they come and they say, no, I want my daughter, for example, to get equal share. So from that 1/3, they could compensate and they could make it equal. But the 2/3, it goes, you don't have a say in how it's divided. It goes based on the laws of the Quran. No. The money, 3 portions. 2/3 goes to the way it's supposed to be distributed. The 1/3 is yours. It's 3 portions. Yes. When you're alive, you do whatever you want with your money. But when you become ill, in your terminal illness, then that's when you become mahjur, meaning you don't have the Islamic right to spend it freely as you want. Yes.
Why can't you do the 2/3? Let's say you have 5 kids and a wife, and let's say parents. Why can't you distribute them equally amongst them if you choose to?
Oh, if you don't choose to do anything with your 1/3, it will all equally be.
What about the 2/3 if you do a wasiyah prior to that?
So if you
have to follow the.
no, so basically, if a person dies and they have not done a wasiyah.
Then you do it.
No. If a person dies and they don't have a wasiyah, all of their money is divided based on the laws of the Quran and the laws of Islam. The wife gets a share, the husband gets a share, the children get a share, the parents, if they're alive, they all get a share. But you have the right to take out 1/3 and do whatever you want with it. You have the right. But if, say, I did not do anything with that 1/3, I didn't even write it. I said let them deal with it however they deal with the 2/3, then they will have it.
I think I have the same question. Let's say you have 5 kids and you want to do everything you own equally. You could write this while you're alive.
Yes.
And then if you die, they get equal. Right?
In the wasiyah, you could say, for example, the 2/3. I can't come and say, for example, I want the girl to get equal share of the boy in the 2/3. But I could come and say, where's the loss? For example, the boy is getting 10 and the girl is getting 5. So I come from the 1/3, I come and I give 5 to the girl. Now they're equal. The 1/3, you do whatever you want with it. While you're alive, it's not even a wasiyah anymore. I know some people, before they died, he came and he gave his daughter this, he gave his son this, and they gave everything. When he died, died in the clothes that he was wearing. And this is probably the most noble thing that a person could do. Give it away while you're alive. Yes, sister.
So just to clarify, we cannot write it in wasiyah that we are gifting this. We give them, maybe make another document or something that this is gifted to.
If you give during your life.
But not in wasiyah.
No, once a person dies, the wealth automatically transfers. You don't have the right to give it. You could give it during your life.
So to put it in simple terms, during my life, if I want to give something, I don't want to make a will. If I'm making a will, it goes only to the 1/3 of what I owe, right?
Yes. Yes.
But if I'm alive, I can give as a gift, say, equally to all 3 of my kids. Then I make another document, and that could not be the wasiyah.
Yes, that would be a stage prior to the wasiyah. Prior to death even. Yes.
One
Yes, brother. Yes, okay.
So is it just the wealth or like it includes all the assets too, like monetary wealth?
All assets, yes. Everything in your assets gets passed on. Yes, brother.
We don't do the will. Let's say you have a trust, you own a business. You want to distribute their business like amongst four people, the wife and the three kids. Evenly, 25% each person. You already put it in the trust, not in the will. Is that allowable? Because you,
So you could give them ownership before your death. Give them ownership of it. If they don't have ownership of it, then it's your ownership.
ownership after I die, they actually will get the shareholdings of the company.
So this is the tricky part, because you might be playing with the rules of God, because Allah subhanahu wa ta'ala says the moment you die, this is how it's supposed to be.
Trust and will are two different things.
So maybe we'll let the lawyer answer that.
So there are different kinds of trust, but a revocable living trust, which is referencing, you still have complete power over everything while you're alive, so it's still your property. If it's an irrevocable trust, that's different.
So we'll let you come up here and you'll go over the legal aspect, and then if there was a need for me to come up again, I'll come up. I ask you all to welcome Brother Muhammad Ali Banoon, lawyer with loud salawat ala Muhammad wa ali Muhammad.
صلوا على محمد وآل محمد. Thank you, Sayyidina. I think Sayyid did, alhamdulillah, an amazing job with covering not just the ethical, moral aspects of the will, but also some of the technical, legal aspects of the fiqh part of it. Let me start. Assalamu alaikum, everyone, brothers and sisters. Of course, I start with appreciation, not just for Sayyid Saleh, the brothers that put all this together, but also everyone here who took 2 hours out of their Friday night to come and listen to something that a lot of people see as either boring or maybe even a little bit frightful in a way, that you don't want to be thinking about these kind of topics. But I think it shows everyone's character and their willingness to accept this inevitability and also to kind of do the wise thing in terms of planning for it. And let me, I don't think it's working. Oh, yeah, it worked. So don't need to do an introduction. I think we're running a little bit short on time. Thank you, Haj, for the generous introduction. This is my information. If anyone needs to get a hold of me, take a picture of that, or I have some business cards to pass along afterwards. So what's the goal of our, inshallah, session today? It's to have a basic understanding of the laws of wills and the states, especially as they intersect with our Islamic laws, with the Sharia, and have that as a starting point for us to start planning, to start writing our wills. Now, at the end of this session, I'll have a link up where everyone can go in. There is a service that we're providing at Law Group where everyone can get a free will. You go in, there's a portal, you provide your information, a little bit of information that will go through what information you need for a will. Once you have all that, you'll be emailed a will, and you can take that, print it, sign it, have it witnessed and notarized. We'll go through that process that needs to be done to make a will formally effective. So my approach for this session, inshallah, will be to try and cover these 5 questions. First, why should I have a will or a plan, and what happens if I don't have one? How do I write a will? What do I need to make sure that the will complies with Islamic laws, with the Sharia? What are some other objectives that I might be able to achieve through the process of estate planning? And what are the different vehicles, a trust was mentioned, that I could use to achieve those objectives? So inshallah, I'll try to answer those questions one by one. So first of all, what happens if I don't have a will or I don't have a plan? Number one, the first question that a lot of people ask is, will the government come and take all my money? And sorry, Sayyidina, no, that's not usually the case unless you owe the government money, then they're going to take it back if you owe them taxes, or sometimes if you owe them Medicaid recovery. So if you, God forbid, had to kind of be in long-term care, Medicaid had to pay for your expenses, they might come back and ask for that money back, right? So unless those things are true, government won't take your money. Also, unless you don't have any heirs, so you don't have any living relatives, then the government might come in if you don't have a will and take that money. There's the other potential for losing money, which is not that the government might come and take it, but that it becomes unclaimed. What do I mean? Sometimes there's money that we own, that we have a right to, that we don't necessarily understand or are aware of, or maybe have forgotten about. I have a lot of clients that come in and talk about retirement accounts from previous jobs that they don't necessarily know how much is in there, how much it's grown, who's entitled to it, who's the beneficiary. If you don't have all that information, then there's the possibility that your heirs might not be able to get access to that money, and so it ends up going to the government. The government will hold it so that people can come and look for it. If your heirs don't know to actually look for it, it's going to eventually end up being taken by the government. So government doesn't just step in and take all the money. There are fees. There are probate taxes. There are court fees that might have to be paid in the probate process, but we'll get through some of that information later on. So if I don't have a will, I don't have a plan, who's going to take care of my kids? I also get that question a lot, which is, first answer is the other parent, whether you're currently married or divorced. The other parent, if they're able and if they're available to take care of the kid, they'll be given that right. Now, let's say something happened to the other parent, or they're not able, they're not available to take care of your kids, then it's going to be the closest living relative or any other relative that stands up in front of the court and asks the judge, I want to be a guardian of this child. Now, again, this is if you don't have a plan. If you have a plan, if you have a will, you can assign in your will, nominate a person to stand as guardian for your children. So if you know who you want to be raising your kids, how you want them to be raised, then that's a reason to take the proactive step towards having a plan, having a will that allows for that. Who's going to take care of my funeral, to take care of my assets? And that's, again, the spouse, if they're available, close to living relative, or any other relative or friend that stands up in front of court and asks for that right. So now you have to think about your family, your friends, who's going to take that step to go to court and make sure that they're fighting for your rights.
Do you want to keep the questions for later, or if anyone have any questions about any of these points?
I can take questions as we go. Yeah.
If you go back to the previous slide, you mentioned something, if you don't have any relatives, can a friend step up and ask for guardianship?
Potentially. I mean, again, you don't have any documents, you haven't planned for this. A friend can step up. If no one steps up, then they're going to go through the foster care system. Even if a friend does step up, then there's also going to be a process. There's going to be court dates, there's going to be, the judge is going to look at what's best for the child, and they're going to decide based on that. That's going to be time consuming. In the meantime, they're going to be in the foster care system, right? So if you want to avoid the foster care system, the best thing to do is to name a guardian for your kids through a will. Clear? Okay. For your assets and for your estate, again, anyone who's willing to come up and stand for that, unless, again, you name an executor, a personal representative in your will, they'll be able to come up and do that on your behalf. What will happen to my assets? So, the technical term for what happens to assets if you pass away without a will is called intestacy. So there are these laws in every state. They're called the laws of intestacy, and they govern what happens to your assets. In most states, they look at the spouse and they give them the greatest rights. A spouse in the state of Michigan, if they're a married couple, no previous marriages, potentially could have a right to the first $150,000 of the estate plus half the rest, right? So that depends on the state, but in the state of Michigan, that's the case. Sayyid Saleh mentioned about the right of a spouse Islamically, which is 1/4 or 1/8 for a wife with children. That clearly contradicts with the laws of intestacy. So if you want things to be taken care of in terms of the way that the Quran states, and the way that Allah subhanahu wa ta'ala dictated, then you would have to plan for that. Will there be family conflict? And that's a question not for me, but for you. Each one of us knows their family and knows if there is going to be any conflicts in any of these things that I mentioned. Is there going to be a conflict in terms of the division of the assets? Is there going to be a conflict in terms of who gets to raise the kids? Again, if you don't plan for it, then it's going to end up in front of a judge. Your family may be in agreement about what happens, or they may be in disagreement. And so if you want to prevent the disagreement, you have to be clear, you have to set out a plan and make sure everything is stated so that they know what will happen with every single point in those points. Another thing is, what if I'm disabled or have some kind of medical emergency? Unfortunately, I have a lot of people that come to me and say, my parents, unfortunately, are developing Alzheimer's or Parkinson's, and now we need to be able to take care of them. And usually what happens is they go to a hospital refuses for the individual to make those decisions on behalf of the disabled parent, and they ask to go to court. So you have to go to court, petition the court for guardianship or conservatorship, and then through that process, you end up getting the final say in how your parents are being treated medically. And to avoid all of that, we go back and say there's the potential for writing powers of attorney, medical powers of attorney, that state how you can, or who has the right to take care of you in case of a medical emergency. So those are the things that would happen if you don't have a plan. Now, I call it a plan because there are different levels of planning. The respected Sayyid spoke about wills. One of the gentlemen asked about trusts, but I would categorize it as 5 different levels. First, a lot of people actually, I think statistics say 50% of Americans don't have a plan. They don't have a will, they don't have a trust, they don't have any of that. The higher level than that is to have a basic will. This is what I mentioned at the beginning, that will have a way to create a basic will that will be sent to your email. You'll be able to take it, have it signed, notarized, and be able to assign in it a guardian, assign in it a personal representative who would stand in court for you if you pass away, who you want to raise your kids, how you want some of your assets to be divided, and all of that in a simple will. A level above that would be a more complicated will, where you are actually dividing your assets maybe in more detail. You might even be able to create something for generations to come through a testamentary trust, one of the kinds of trusts. So the more complicated, the more advanced you want to get with that, the more you can through a will. The next level would be a trust, which would allow you to achieve some higher objectives in terms of what you want to do with your family or with your assets, in terms of some objectives, and we'll cover those objectives later on in this session. And then there can be more complex trusts for more complex strategies. Again, that comes down to what your objectives are for this planning process. Yes? Again, it depends on, number one, your personal family situation, your personal assets and wealth, and also your objectives for how you want things to be handled post-death or even during life in case disability and medical. I think that might be a little bit more clear if we pass through, or if we go through the rest of the presentation. If that question remains, then I'll go back and answer it.
So if you have a will in place and you have 401ks and bank accounts already have a POD assigned to them, does that will override that POD if you have not updated it in a while?
A very good question. The will doesn't affect the POD. So POD is a designation of beneficiaries that you say in your bank account or in your retirement accounts that if I pass away, the money goes to, for example, to my wife, to my children. The will doesn't affect that, legally speaking. The will does not affect that. The will handles property outside of that, right? So the will doesn't manage that. That goes back to whoever you designated. Now, we can ask Sayyid Saleh if that money is a part of the full estate that needs to be divided 1/3 by 2/3, right? So that money might still have to go 2/3 of it to your heirs Islamically, even though it doesn't go through will legally. Okay, is that distinction clear? So why don't people, if a plan, if a will is so important, why don't people actually write a plan or write a will? A lot of people say it can wait, and we all know, and that's why we're all here, that sometimes we don't know whether it can wait. Sometimes things can happen suddenly, unforeseenly. A lot of people say, I don't have enough assets for an estate plan or for a will. And again, that's false, because anything that you might have, again, from a moral perspective as well as from a legal perspective, you have the ability to direct Islamically a portion of it, legally all of it, through a will. Some people say it's too expensive. And again, it might be more expensive to pass away without a will than it is to pass away with a will. Okay, so let's get to the formalities of writing a will. Yes? I have a slide on that. I have a slide on that. Let me get to it, and then you can ask the question again if I don't answer it. Okay, so writing a will. First of all, a will is a very formal process. Legally speaking, we want to make sure that people understand what a will is and that they're doing it with sound mind and they're not being forced into it, they're not being taken advantage of. So we require it to be in writing, we require it to be signed, that there be 2 witnesses, and in some states that it be notarized, right? And so it's best to kind of make sure that it's signed, witnessed, and notarized wherever you are in any state. Make sure it's notarized. So once you have that, you have a will. So who can write a will? Any adult can own that they know who their relatives are, and that they know that by signing a will, they're allowing them to take possession of this property after they pass away. So those are the kind of questions you ask a person to make sure that they have sound mind to be able to write a will. And you can tell that it's not a very high threshold, but again, with some people who are suffering from, God forbid, Parkinson's or Alzheimer's, they might not be late to write a will. Also, again, a person has to be doing it freely, so they can't be under duress, they can't be forced into it, they can't be taken advantage of. What should a will include? First of all, you have to identify yourself as the person writing the will. Usually we do that by writing the name, but also writing some clear characteristics like address, who I'm married to, who my children are. And then you can name a personal representative, or you might have heard of it as an executor, a person who takes the will and actually takes it to court and enforces it. And that's another thing about wills. It has to actually be certified by the court, but we'll get to that. Yeah, you can name a guardian for your kids. If you have minor children, you can nominate a person who would be able to take care of your kids, and you can give directions on how they should do it. You can make specific distributions of property. So you can say, I leave, let's say, my car to my son, or 15% of my assets to my daughter, whether it's an actual item or a percentage, you can do that in a will. And then you have to identify where everything else goes. So you can say, my car goes to my son, 15% goes to my daughter, and then the rest goes to my wife. Now, again, Islamically speaking, there are specific ways that these need to be divided. 1/3, 2/3, specifics of the inheritance of the 2/3. The way I would suggest that a will be written Islamically is to go through the inheritance, go through your specific family situation, and say, for example, I have a single daughter, she gets a half, and so on and so forth, and incorporate that into the will. Other question I get asked sometimes is, can I disinherit my wife and my kids? If you have minor children, you can't disinherit them. If you have a spouse, you also can't disinherit them.
Disinherit means taking them out of the will?
Yes, taking them out of the will so that they don't get anything. Yeah, so you can't do that to minor children. You can't do that to your spouse. The spouse has what's called an elective share, and that depends on state law. So in the state of Michigan, one example, I think I already mentioned this, which is if you're married, no prior marriages, you have children, the spouse gets $150,000 plus half the rest, okay? So if you leave a will that gives the spouse less than that, they have the right to petition to the court and ask for more. You can potentially limit that in a will by saying that, for example, my wife can't get more than half of that elective share, but there's always a potential for that to be not enough in view of the court, and that the court will basically give them more. Now, before that might sound a little bit kind of scary because it contradicts the Islamic Sharia so much. There's always, number one, the spouse doesn't have to they don't have to contest the will. So if you're married to a believer, someone who fears Allah subhanahu wa ta'ala, they're not going to do that. But also, you can get a waiver of that beforehand. And usually that happens in a prenuptial agreement where you waive your spousal right, and that way, that possibility isn't even there for them to go to court to contest the will and get more than that. Does that clarify your question? Okay. Can I change my will? Short answer, yes. You can completely revoke it. You can toss it out. You can write a new one. You can just shred it and go back to not having a will. You can even edit it. You can edit it by what we legally call a codicil, which is a document attached to it that says, I've made these changes. One thing I'll warn against is don't go around crossing things out and adding things in, because that could potentially create more confusion. If your will was written in a specific way, you might not be able to, or you might unintentionally cross out the wrong thing, or not cross out the right thing, or create more confusion by doing that.
Does it have to be a hard copy? It can't be saved in a database somewhere?
So there has to be a hard copy, because courts, and that might differ from state to state, but in Michigan, courts require an original ink signature on the document, right? So just having an electronic copy might not be enough, right? Or electronically signing a copy might not be enough. So ink signature needs to be present. And that's why we usually tell our clients to keep the will in a safe place, either next to their bed, or even if they can, in a safety deposit box or something of the sort.
So I'm asking these questions, but if they get lost or something, it's gone, right?
Yeah. Yeah, so you'd have to have the original one. We usually, as attorneys, we keep a scanned file just in case there's something that happens where we can't find the original, but the court does want the original. And if you don't have the original, you have to justify it in some way. And if you've lost it and you're still around to kind of make a new one, then you should make a new one.
Can you make sure you do multiple copies and sign each copy and become original?
Would not recommend that, because there is the potential that, again, if you wanted to change or if you wanted to completely revoke, then exactly. There's the potential for multiple originals, contradictory originals, to be floating out there. That's going to create more problems than you've solved, right? Okay. Clear on this one? Okay. What a will can't do. So it's important to realize what a will does and what it can't do. So number one, it can't avoid the probate system. A will needs to be certified basically by a judge. The judge needs to have it in front of him, stamp it, and say, I give the personal representative, the executor, the power to act in accordance with the will, right? And that could be time-consuming, and it could be expensive. It can't avoid any taxes. So if you're in a bracket where you're worried about estate taxes, which most of us, inshallah, most of us aren't, inshallah, some of us are, which is around 26 million. Most people don't have to worry about that. But if you're in that bracket, a will can't change that for you.
If you have more than 26 million?
There's a potential for estate taxes.
Oh, but below there's no estate tax?
No estate taxes. Now, that number changes, and there are some states that have different numbers. This is the federal number. I have a slide on it. The other thing a will can't do, Afwan, Fadl. I'll get to it. The other thing a will can't do is affect joint property. So in the US legal system, most states, if you jointly own property, meaning that, for example, me and my wife, both our names are on the deed to the house, that's not affected by the will. And what happens is that if one of us passes away, the house is, so me and my wife's names are on the deed, I pass away, my name basically gets scratched out, and the house remains in her name. Now, that's what happens legally. Again, you go back Islamically, was that her right to kind of get that other half of the house? We don't see it as getting the other half legally, but Islamically, it could be problematic.
What if the deed is in one person's
then it goes into what would happen with either if they had a will or if they didn't have a will, you'd have to go through that whole. But if it's jointly owned, that's where a will doesn't affect it, because what we say is your property right got extinguished at death, so you don't have a right to it anymore. You couldn't have done anything with the will to change that, so it doesn't pass through will, it passes outside of probate.
If both die, then you have to have it in the will.
Yeah, yeah. If both spouses die, then it passes on to their heirs. If you have joint accounts, that would be the same. So if one of the spouses dies, they scratch their name out, and it remains the property of the other individual. Life insurance is different. Life insurance, and correct me if I'm wrong, Said, from what I've seen from Said Sistani, it passes completely outside of that, right? So legally, life insurance isn't your property, but someone has a benefit to it, right? So for example, if I have my kids on the life insurance, if I pass away, my kids get the money directly. So it's not through the probate, and it's not through, even Islamically, it's not through the 1/3, 2/3 division. There is a potential, just because tax laws are different than probate laws, that it might be taxed if you hit that $26 million mark, but that's different. Already went through joint property. Okay, so how do I make sure that my will is Sharia compliant? First of all, we have to understand the Islamic laws, and I think Sayyid Saleh did a great job of doing that for us. And then we should incorporate those laws into our will. So first of all, we have to understand that 1/3, 2/3 division. That 1/3 that we have the power to divide or to allocate in whatever way we wish, we write that in the will. And then for the other 2/3, we should also state how that division is going to be. So my example, if I'm married, I have a single daughter, I have my parents are alive and well, so 1/6 to each of my parent, 1/8 to my wife, 1/2 to my only daughter. That's the division that would be according to the verses from Surah An-Nisa. The complexities start to add up when those fractions don't add up to 100%. So what happens to a shortage? What happens to an excess in terms of those fractions? That's something that each individual should assess on their individual basis, based on their personal family situation, and incorporate that in the will. Because otherwise, if I put a will in front of a judge that says, divide this Islamically, the judge is not going to know what to do with that, right? And they could potentially just throw the whole will out because they can't act on it, right? So that's why it's important to have that division incorporated into the will. There aren't much differences because a woman is entitled to her own property. So are you asking this from an Islamic perspective or a legal? From a legal perspective, it depends on how they're titled. Are they titled jointly or not? From an Islamic perspective, she had the right to have her own property. Her property, once she passes away, is divided according to the same divisions. The only differences is where, in some instances, in some cases where there is where there's a double for the male heirs. And I think you can, again, assess on a personal basis, case-by-case basis.
Is it considered legal to not you just specify, I want to divide it based on the Sharia law of the Muslim Shia faith, for example?
So there's nothing wrong with that, except that it creates possible room for family conflict and for the will being contested in court. So if your family can't agree, or if, la samhallah, God forbid, if you anticipate that one of your heirs might not be understanding of the Sharia, that they might want to contest the will, then they could potentially jeopardize all of that, right? So to reduce family conflict, to make sure it happens the way you want it to happen, according to the Islamic laws, you incorporate all of that into the will. Okay. I think Sayyid Saleh did an excellent job of going through a lot of these scenarios. Okay. I also want to make sure I have some time for question and answer in case I haven't answered anyone's questions. So, objectives to estate planning. What are some objectives that can be achieved through wills, trusts, powers of attorney? What are some things that we can do with this estate planning process? First of all, let me give a little bit of a background on trusts because, again, that term has been thrown around a little bit. So what a trust is, I usually say it's like a box. So you create this trust and you put your property inside that box. While you're alive and well, you have full and absolute control to do whatever it is you please with whatever you put in that box. Once you pass away, that box automatically gets shifted to the next person over. So whether it's your spouse, your children, that box just moves along, and now they have complete ownership of that property. Okay? So that's how a trust can be used. That's the way it can become beneficial to talk about. So what are some objectives that we can achieve? First of all, we can put in there some language to protect spouses and children. So for example, if I have an inheritance, I know that, for example, one of my sons isn't great at managing money, there might be an impending bankruptcy case. I don't want them to lose the inheritance I'm giving them directly when they receive it. Potentially, I could build in some creditor protections for them in the trust. Disabled beneficiaries. If I have children or other beneficiaries that are disabled, I don't want to give them that money if that's going to jeopardize their government assistance. They're going to lose their Medicaid, and now they're not going to be able to get the treatment that they want. I want to make sure that I build it into the trust where I make sure that they continue to have the eligibility for government services. Planning for my personal, God forbid, disability. What happens if I'm disabled? How should my assets be controlled? Or who should be making decisions, both financially and medically? Tax planning in terms of estate, gift, and income taxes. So in terms of estate taxes, we mentioned the $26 million number. Gift taxes is similar. If you give gifts more than that number throughout your lifetime, or more than $16,000 to a single individual during a year, then it might be taxable to you, right? Not to the person getting the gift, but to you as the person giving the gift. So those are some things to consider as well. And then you could use the trust to kind of plan for that. How can I save the most taxes by utilizing those tax? Oh, I'm sorry. Okay. Yeah. Other objectives, asset protection. If I'm someone with potentially high risk, for example, medical doctors, I want to make sure that no one can come and sue me and take all my property and I'm left with nothing, my family's left with nothing. There's a potential to have asset protection trusts that will save something for your family. Business succession planning. If you have a business and you want to make sure that it continues to operate successfully after you pass away, God forbid, then that's something to build in both in the business and in the trust. Ensuring family harmony. So if there is potential conflict that you foresee between your kids, between your heirs, then how do you deal with that? How do you make sure that everyone is happy and there's no chance, not necessarily that everyone's happy, but that everyone knows exactly where the lines are as well, and they won't be crossing it in terms of contesting the will and things like that. How do you preserve family values? So I have clients that come to me and say, I want to make sure, yeah, I have this wealth that I want to pass down to my kids, but how do I make sure that they don't become trust babies, that they don't become just dependent on the trust, that they go out and earn their own decent living? How do I make sure that they get an education? How do I incentivize them to get married, for example, and start their own families? Expenses, or the trust will invest in your business. All of these things are things that you can do to preserve potentially your family values. There's also charitable planning. So that ranges from, for example, saying 1/3 of my assets in your will, saying 1/3 of my assets to my local mosque, or saying that I have this sizable number of assets, I want them to be invested, and then they can be donated to charity during my life or after my death, potential tax benefits of that. Thing in the US called pet trusts. So you can leave a trust aside for your pets to make sure that they're taken care of. I only mention that to say that the possibilities are endless. Whatever objective you can come up with that you want to achieve through a trust, there's probably a legal vehicle for you to do that.
Money in a trust is taxed the same way.
Depending on the kind of trust, money in the trust can be taxed on growth, right? So if there's a business in the trust, if it's making money, then that money could be taxed as income, right? So that's income taxes. I would say so, yeah. So, so the, so you can set up the beneficiaries according to the divisions Islamically. So again, I have a single daughter, she gets half, I give her half in the trust. My wife gets eighth in the will, she would get an eighth in the trust. Or potentially I can just build the trust, if there's sizable assets, build the trust with just my 1/3 and then distribute the other 2/3. The other thing that trust can do, and I'm not sure, I don't think I have it in here, which is actually going back to protecting spouses and children. So if you have minor children and you're passing things along to them by will, they get complete access to it at that age, right? So it could be a 5-year-old inheriting $100,000, right? And you don't want that because they could either misspend it, who's going to be taking care of them, who's going to be monitoring how they spend the money, as opposed to as trust where you're building all of that in advance, right? So potentially, if you take those considerations in mind, the trust might even be more beneficial because you're, again, establishing your values, making sure everything is done correctly from an Islamic perspective. Answers your question? So I think I was asked about what's probate, probate process. So probate is basically, court opens a case, the family goes to the court, they provide an inventory, a list of all their assets, and then the court makes sure that, number one, that creditors are paid, and then that the family divides everything else, either according to the law or according to the will. There is no abuse or misuse. No one's taking advantage of anyone else after the creditors are paid. So that usually is a lengthy and expensive end to attorney fees in that process, appraisers, whatever it might be, to make sure that the case goes through that system, and that actually could last from at least 6 months. Based on the statutes in the state of Michigan, there's a waiting period. You can't close it before 6 months, just to get all your property across the probate court and make sure it's distributed to your heirs. That's why I mentioned avoiding probate as one important objective to be achieved. Now, the other thing is, if you have a will, like I said, it doesn't avoid probate for you. So you could have a will, the will needs to be presented to the judge needs to approve it and ask the personal representative to act in accordance to the will.
So only through a trust you could avoid probate, right?
Through a trust, or if your assets are small enough. So in the state of Michigan, if your assets are less than $50,000, avoid probate. Also, like I mentioned, joint property isn't accounted as part of that. So you could, for example, jointly own the house with your wife, have assets over on top of the house less than $50,000, and then you would be avoiding probate. The other thing that's available to you in the state of Michigan, actually, is what's called a ladybird deed. So you can even, in the deed of your house, you could write, this house belongs to me or to me and my wife, as long as I'm alive, and then when I pass away, it packets. And that way, it doesn't go through the court system.
Does that affect Islamic laws?
So, from my understanding, no. So,
If you actually put the kids on the deed, it shouldn't be a problem.
if they're owners on the deed,
Yes.
then they would own whatever portion you have them as on the deed.
As I'm alive, basically.
Yes,
Whether it's
yeah.
quarter or
Whatever's on the deed or whatever, either an equitable share or whatever's on the deed.
God says, no, after you.
If someone doesn't have a trust, and the house is not, they didn't put that, it passes on to the children.
Then,
Will the government or
then it would have to go through the probate court. It will still go to the children, but it will have to go through the probate court.
process?
after that process. So they might have to be.
Longer process too. If they're underage, it's a longer process.
Yeah, potentially, because you'd have to figure out who's gonna handle that money on their behalf, right? So unless you've left a will, assigned a guardian, appointed a guardian, all of that the court is gonna have to consider.
Now, could that be also done for commercial real estate? What we just discussed, having other individuals on,
Yes, for commercial real estate, you can do that. You could also, through your business planning, so if the commercial real estate is owned by an LLC, you would have an operating agreement that potentially you can make sure operates in the way that you want.
not breaking any Islamic laws.
That's a question for the Sayyid maybe, but as far as I understand, yes, you would be, because you've owned it during your life, and so even though you've put in place an automatic trigger for it to transfer after your death, you still owned it up to the point of death. So if you've owned it up to the point of death, then Islamically, it's within that 1/3, 2/3 division.
If I place them on the deed prior to, like right now, let's say I put them on there as we speak.
If you've given them ownership during your life by placing them on the deed, then you should be fine.
Loophole, but I'm just,
Yeah,
that way I want to distribute it equally amongst them if I choose to.
yeah. So I think the bottom line is, if that's your objective, then go back, look at your objective, and make sure that you've done that, also making sure that you haven't. Inshallah. Yes, go ahead. Mhm. No, they would be passing outside of probate. So for example, life insurance. If you have life insurance, you have correct beneficiary designations, they'll pass outside the probate process. Beneficiary designations. Or if you designate it to, for example, my wife who passed away before me or at the same time, then it could end up in the probate process. The other thing to consider, I think I mentioned this, is that the probate process is one thing, and then estate taxes is another thing, which I'm getting to, which is it could potentially be taxed even though it's outside of the probate process, if you get to those numbers. So the current numbers for estate taxes federally is $12 million per individual, 24 for a couple. I think that changed as of the beginning of this year. It's adjusted for inflation, so it's basically where you live and where you own your assets that might also be triggered in terms of having to pay estate taxes. So for example, if I own property in Maryland, I might have to pay estate taxes on that property because I might be subject to their laws. A similar thing is gift taxes, which is if I give a gift that's substantial, it might be taxable to me. So if anyone has assets that add up to these amounts, I know they sound astronomical to most. Yes, so for them, right? So if I give, say, Saleh $16,000 or $18,000, I might have to pay taxes on that personally, not you, me, right? Yeah. So, and then there's a, I believe that's 30 or 40%. Estate taxes is 40%. I believe gift taxes is 40% too. Yeah, so there's a per person per year limit, which is 16,000. And then if you go above it, then there's an there's a lifetime limit of, again, it's 26 million for a couple right now. So then if you go over 26 million for a couple, this is significant and important for billionaires, but not most of us.
Already, if you pay like taxes,
Mhm.
if you earn money and pay taxes on it already, then if your case like 12 million, you have to pay tax on it too.
Yes, so income taxes is one thing,
Double the tax. It's gonna be
because there are different kinds of tax. So you pay sales tax, and then you pay income tax, and then you could pay estate tax and gift tax. The IRS gets their money. Gift taxes, yes. Yes, yeah. Yeah. So there's a per year limit, and then there's a lifetime limit. So if you hit the per year limit, then it's going to count against the lifetime limit. then if you pass the lifetime limit, then it's taxable to you. So
What if, sorry to cut you off, but what if you loan it to your son and your son never paid you back?
sounds like tax evasion to me.
I'm saying,
If you structure it right, potentially. Given and then they might be taxed on it themselves, but yeah. Okay, I think we talked enough about taxes, generally on property. Life insurance and retirement accounts. So mentioned that also briefly, which is life insurance passes outside of probate. Same thing with retirement accounts, as long as there's a proper beneficiary designation on them. There are potential tax advantages to having your spouse named as the beneficiary. So if it's not your spouse that's named as a beneficiary, retirement accounts could potentially be taxed. That's a complicated question for your accountant. Okay. Yes. Yeah. Yeah, so according to company policy, I guess, you would get their signature to be, or you would have them as beneficiary, or if you got their signature and they've said, I don't want to be the beneficiary, the kids can be the beneficiary, that could potentially become taxable to the kids when they get that payout. Right?
If I have life insurance and like if I die, then it will go to my wife. But what if we do like a car accident and we both die? Do they go like to the kids? Do we have to write it down?
So it's gonna go to your estate, which means court is gonna open a file, they're gonna look at the life insurance, and they're gonna see where it goes, most likely to the kids, right? Exactly. So what you can do is you can name a primary beneficiary, and then you can name secondary beneficiaries, which is to say, if that contingency happens, then they would be the ones to take that money.
Other than life insurance, say that your HSA account, your all the assets, others, that kind of like work for like an employee, right?
Mhm.
What else, like in the federal side, like as example, our SSI or the Social Security benefit, how we can get this if someone really, like what they are, what's out there, we don't know.
So there is potential survivor benefits on the Social Security side, but those are, they're very specific in terms of the rules. So with retirement accounts, you're putting money in, and you're gonna end up getting that money back either to you or to your spouse or to your kids. With Social Security, you're putting money in, you don't know how much you're getting out of it. You're not getting the same amount. And then there's your benefits, there's potential survivor benefits for your spouse. So there might be money out there, there might not be money out there. You'd have to kind of look at the specific scenario.
And then, like, should I like put it in the will, or how is that gonna work?
For Social Security,
Yeah,
it's not really your property. What's in Social Security's hand, it's not your property, it's a government benefit, right?
government should take care of it.
Exactly. Now, your spouse should know whether there's a survivor benefit or anything like that. Again, going back to one of the first slides I did, there's something called unclaimed funds agencies in the States. So if your kids, if your wife, if your kids, they don't know what you own and you pass away, la samahallah, then that money could potentially be lost, right? So it's important to communicate to them that, hey, this is what I own. If something happens to me, make sure life insurance pays you. Make sure my retirement account, they get paid out to you, right? So it's important to have that clear communication.
Second question. If we move actually from the state to different state, should I actually change the trust or the revocable trust and the will?
If you keep connections with the previous state, for example, you keep your assets there, then you don't have to do that. But if you move completely, move all your assets, sell your house, buy a new house, then potentially you might want to do that because, again, there's potentially different laws. Now, there might be you might have to amend things instead of doing things from scratch, but that would depend on the case-by-case scenario.
The last question this life right now, so that kind of everything is joint.
Mhm.
Myself, my wife, right? So we work, we pay actually for the house, we do everything actually joint. So legally as well in the Islamic law, probably the state actually be held here. How we can actually kind of do the inheritance actually? How we gonna separate it? Like I can't really tell. Okay, everything I own basically.
Try to come up with a fair division. If there isn't a fair division, then for example, if it's joint, if me and my wife are both on the deed, then it's assumed 50-50 because it's just two people on a deed, right? Unless there's a fair way otherwise to divide things.
Yeah, I mean, probably the same answer, and this always comes up when it comes to khums as well. Sometimes people, couples, they have a shared account and they don't know whose money is which. And that's why it's advisable, you could still love one another, you could still respect one another and cherish one another, but it's advisable to kind of know where's your money and where's her money, even though you live your life in a way where my money is her money and her money is her money. You should know where it is, so that when it comes to homes and when it comes to inheritance, you'll know where to.
The account actually we take care of it, but I'm talking about the asset like house as example.
Yeah.
Both of us actually pay for the house. So how would that get be separate? Yeah, the homeless is actual money and salary. Yeah, we separate them. But
So
the
maybe you
stuff that
could
we
see,
spend-
for example, how much was put, how much percent was put. It goes back to an estimate.
Yeah, like bargain estimate.
You have to agree upon it, that's basically.
Yeah. Thank you.
I think that we had some questions over here first.
A person passes away, and that house, the wife and the children are living in there, but he has his parents, for example, they're alive. Now they have a share in that. He has other relatives that might be alive, they might have an Islamic share in that. So that's why it's important to have this will. For example, you could say, I want, or you could give, during your life, give it to them. Say, for example, this is for you. Or work out an agreement where, for example, I know sometimes they would have to sell that, and I've heard stories where the kids and the mother, the dad died and the kids and the mother had to sell the house because, for example, the in-laws, they were asking for their right. And it becomes your right. The moment a person passes away, the money is transferred the way the Islamic law has legislated. So it's haram to come and forbid someone and stop someone from taking their haqq. Unless there's an agreement before that.
What kind of agreement? Like when the husband basically gives it to the wife?
Yeah, he could give it to the wife, or he could give it to the children during his life.
Yeah, well, exactly, that's what I'm saying. Like, especially if the kids are grown, they're living in their own home, and so at the end of the day, where she doesn't end up being thrown out of the house for the sake of the money, this is her house. So
Yeah,
she'll stay in there until the day she dies, and then make it inheritance after.
So you could basically say, my house, I give it to my wife, or I give it to all my children equally.
Or sell it to them for a lot of.
I mean, at the end of the day, they're gonna get it one way or another after she dies, or let's say that whoever dies first. But I'm saying, if that person stays in that house, the other spouse stays in the house until their death, and the children can inherit it later. But that has to be given by one of the spouses.
So one thing that is done, I've seen done in the Middle East, for example, in some countries, what they do a waqf. Waqf is a trust, right?
Basically, yeah.
Waqf is a trust, meaning that this waqf has to stay in this family. This waqf has to stay in this children. So you could do that. They do that in parts of in some countries in the Middle East where you say that person is in charge of it.
Before I answer more questions, I do have time, right?
Yeah, you have.
Okay. One thing that I want to mention is I mentioned the free will. If you want to scan the QR code or go to that web page, basically it will prompt you to go through a list of questions. You're going to answer about your personal information, spouse's personal information, children's personal information, who you want appointed as a guardian, as a personal representative. If there's any specific gift that's to be made, you can do that. Now, this is what I call a basic will. So you can make a basic gift, for example, let's say to your kids or to a friend. But this will is gonna say the rest goes to my wife, and that's because there's legal reasons, and I can't advise you all personally on whether you can do something different right now or not. So I don't give general legal advice to the whole group. That's the best I can do. So go through that, get that done. If that's to your needs and fulfills your needs, that's great. If not, if you want to go further, also available for that. I should mention that this will achieve some important objectives, which is it will, again, appoint a guardian for your kids in case you want that, in case you have minor kids. It will assign a person to be your personal representative, to stand in court and make sure everything is done properly. And it will, hopefully, if there's a chance for family conflict, this will reduce that chance. So there's important reasons to have that, even though it's basic, even though it's simple, but it's a first step. So I advise everyone to go through it.
So is this something that you fill out and print and then bring it to you?
So you fill it out, you print it, and then you can come to my office. It's just gonna need basically your signature with witnesses and a notary. So you can come to my office, you can go to a local bank, and you'll be able to finalize it, and everything will be set.
So someone could basically fill out a will without going to a lawyer. They just need two witnesses, a notary, and that's it.
Yeah. You don't necessarily need a lawyer.
Any paper.
Yeah.
They're available online, so people do
Yeah.
it.
Exactly. There are forms available online.
Trust is different.
The trust is different. This is a basic, simple will. If you need legal advice to a group.
Yes.
So just
Okay.
to put things in simple terms at the end of this. So if I don't have any will, I want to do something, right, for the family. I think the trust is the best option, right? And before I do the trust and I go to you, I have to look Islamically into how I'm going to divide things between my wife, my kids, the family, everything, and then I go put that in a trust. This is probably the best thing that you recommend.
I would say yes, except that it depends on your personal family circumstance and your assets. So I think I may have forgotten to mention it. It was on there. But in the state of Michigan, if your assets are below 50,000, actually I think I did mention it. If your assets are below 50,000, then you might not need to go through probate. So you don't necessarily need a trust as long as things are figured out with the family. But yeah, if you have assets, you want to make sure that they're passed on correctly, then yes, find an attorney, make sure that they do it for you. The other thing I'll say, excuse my Jasara Sayyidina, but I'll be able, inshallah, I'll be able to guide you through the Islamic side as well. I have some background in that. But if there's anything that I might not be able to answer for you, then say is available. The scholars, inshallah, we can refer to.
And for the guardian, what's the age? How old does he to be a guardian? If you have
Legally 18, but depends on, again, family dynamics, who you trust to be the guardian. Is an 18-year-old going to be qualified to look after a 2-year-old? That's depends on the person, up to your family. I think there were some questions over here. Let's be kind of equal.
I just have two questions.
Yeah.
Is the notary required in Michigan?
For a will, if there's a notary, it would be called a self. Short answer is it's best to have not necessarily required, but best to have a notary for a will.
And then my second question is, when it comes to debt, Said, you mentioned earlier that you should write all your debt in your will that you owe. Would that be on the oldest child to pay off the person's debt after they pass away?
Not necessarily the oldest child, but even in an Islamic will, you have to.
Financial debts, right? Not the prayers and the fast.
Yes.
Okay.
So, for example, now the assets here are, mortgage-based or something like that. So if our husband owns everything, like the house and the car, whatever it is, would it still be transferred to the wife after he passes away? And will the debts be transferred to the wife?
So legally speaking, the house is owned subject to the mortgage or to the lien. So that transfers with the house. So the wife would get the house as well as the mortgage on the house, right? So then she'd be liable to pay the mortgage. If she can't, then potential foreclosure and so on. But I hope that answers your question from a legal perspective. Yeah.
What if it's the other way around? Let's just say the wife owns the house, it's only in her name, and then she
then again, it would be divided to her heirs, right? So her husband would be one of her heirs, but also her parents, her kids. So it depends on, again, family makeup, composition. Oh, I'm sorry, legally, yeah, if it's just her name, then it would go through the probate process to go to her heirs. The husband would have what's called a spousal share, which would be 150,000 plus half potentially. If family looks different, that might be a different number, but very similar, but with different numbers than the Islamic side. Yeah, yeah. No, no, they won't be evicted in the meantime. But if, God forbid, more there are. So again, less than 50,000, there's a different process. If it's even less, then depending on what kind of assets, there might not be any process to go through. Over 50,000, then there you'd go in front of the judge. You would basically submit what's called an inventory, listing all the property, and then how it's going to be divided, right? If you have a trust, then like I said, it's put in the box and the box transfers automatically. So, yeah. No courts, nothing, except that if you miss something out of the box, again, it's a box, you put whatever you own in it. If you missed putting something in the box, then it's going to have to go to court.
So can you put all my assets are in that box?
You'd have to name the specific assets.
No, what if you're making money now, but then you started that trust a year ago?
Mm-hmm.
You want everything that you make to everything in your bank account to go to people.
So you would name the bank account in the name of the trusts. So then everything in the bank account would be in the trust. The only thing is, the biggest thing I'd say is real property, so houses, houses or real estate. If they're not named in the trust, then they're going to have to go through the probate process, because you want to be able to sign over the deed to the trust. Otherwise, it's going to have to be a judge who signs over the deed to your kids.
Which could also use power of attorney. Like in the meantime, sometimes you can also give it to someone in case something happens to you. They can actually handle those things on your behalf.
Exactly. So powers of attorney could be useful in that if something happens to you, they could act on your behalf. Powers of attorney are no longer valid once a person passes away. So they're completely invalid if someone passes away, so they might not be useful in some scenarios.
What if they're specific to certain things, certain assets?
Even in terms of passing away? Yeah, power of attorney is no longer valid once a person passes away. That's where a will comes in, that's where trusts come in, but powers of attorney are only valid as long as the authorizer is. So they can be, and I would suggest that they should be. And I've done wills and I've done trusts for some clients. There's tabs in it, and like one of the first tabs is a statement of faith where it lists, I'm a Muslim, this is my creed, this is, I believe in that Allah is one, Prophet Muhammad, the Quran, the Imams. And like the Sayyid beautifully said, we're talking a lot about property, but ultimately passing along your values, your religion, that's more important. So even though there is legal aspect to passing along property, that should be a greater concern for every believer. Make sense?
So you define the different type of essential complex, just package complex. How much the cost? What's the cost you have?
There's a big range. So there's a big range from, I'd say, like a complex will, where I just sit down and kind of write a more complex will for you, something more than just the simple will, might cost you $1,000, $1,200. Me or other attorneys, similar range, up to complex tax savings or asset protection strategies. Those could be over. As attorneys, especially as estate planning attorneys, we usually represent each couple. So I would represent you and your wife, you and your husband. And so I'm both your attorneys, and so I'm not planning for one side against the other, or if the husband tells me something, I'm gonna share it with the wife. So one funny thing, some people come to me and they're like, I have these assets I wanna hide from my wife, and that's not something I can help you with.
I have a
ladybird deed. A ladybird deed, or sometimes it's called, the technical term, it's called an enhanced life estate deed. So what I do is, for example, the house is in my name. I write a deed and I say, this house that's in my name, I'm gonna keep it in my name, but if I pass away, it goes on to this individual or these individuals, right? And then that's registered with the county, Wayne County or wherever it is. Then once you pass away, instead of going to court, all your heirs or whoever you named in the deed has to do is take the death certificate to the Register of Deeds, and now they own the property. So that kind of simplifies transfer of real estate. I'd be able to help with that, but I should mention that there are potential complexities with that, especially if there are Medicaid considerations. Then you'd have to see whether Medicaid would want to go after the house or not, and that's could cause complications. Okay, I think that was it. Thank you again. Thank you all for coming, taking 2 hours of your time to have me put you to sleep with this subject. Thanks again.
Thank you everyone for coming. I would like to thank Brother Muhammad. This was very helpful, and it was a lot to absorb, but this is, I think, very helpful overall. Thank you. Just a reminder, we're going to do Salat right after this, probably in another 2 or 3 minutes. So if you want to stay pray with us. Thank you.
His business cards are up here if anybody wants a business card. Can I have some of your business cards? I'm gonna pass them out. Give me a few more. Thank you.
No, I don't. Because we don't have so I got a shipping list. I do. Plus, I got two life insurances. I got a modified too for me. For the sake of how I had to go to I do have a mother and some unfortunately not into quarters. The way I had it, I don't know about what's going on with this new 2/3, 1/3. Yeah. I wasn't told that before. I've asked. They haven't mentioned it.
Yeah, so that's.
I don't know if this does it have to do
What-
with Raja or no?
No, but with life insurance,
Not just life insurance, even let's say real estate. Let's say
yeah.
I have real estate. I look, okay, my wife gets a quarter, my son gets a quarter.
Yeah.
It was enough my daughter. I don't want my daughter to get any less than them.
Yeah. So
That was the plan.
you just have to play with the fractions and make sure that happens.
How are you? Very good lecture. What's your office hour?
Usually 9 to 5, but I usually accommodate clients. I could. I mean, I'm here on
9 to 5.
Friday night at 9.